18 U.S.C. Section 922G is the most enforced federal gun law in America. It is triggered tens of thousands of times every year. It is the law that ends more gun rights than any other statute on the books. And it is the law that more gun owners are confused about than any other, because the categories it covers are broader, more technical, and more legally consequential than anything you have read in a headline. Let me give you the penalty first, because everything else in this video flows from understanding what is at stake. A single violation of Section 922G, possessing one firearm, one round of ammunition, carries up to 15 years in federal prison. Not a misdemeanor, not a fine, not probation, a federal felony, with a 15-year maximum, on top of a permanent lifetime ban on ever possessing a firearm or ammunition again. That is the consequence of falling into any one of the 9 categories this statute covers. 9 categories. And here is what makes this statute unlike almost any other gun law in the country. Most of those categories are not about what you did with a gun. They are about who you are, or what happened to you at some point in your past, and whether that past disqualifies you from ever exercising the Second Amendment right again. Now here's the legal context that makes this statute the most important story in American gun law right now. Because Section 922G is under more constitutional pressure at this moment than at any point since it was enacted in 1968. Justice Clarence Thomas, in his concurrence to the Supreme Court's 9-0 ruling in United States versus Hemani, decided June 18, 2026, wrote that courts should revisit the constitutionality of Section 922G, not just one category, the entire statute. He argued that Congress does not have the power to regulate the possession of firearms solely on the ground that they crossed state lines at some point in the past, which is the entire Commerce Clause hook the statute rests on. Thomas wrote for himself alone. But he put that analysis into the official United States reports. He invited the right case, and the right cases are already arriving. Dozens of petitions challenging the felon-in-possession ban are pending at the Supreme Court right now. The Fifth Circuit has struck down Section 922G(1) as applied to nonviolent felons in 3 separate decisions. The ATF revised its regulatory definition of the drug user category on January 22, 2026. The entire framework of this statute is being litigated simultaneously from multiple directions. I'm going to give you every category of Section 922G, exactly what it covers, exactly what triggers it, and exactly what the key legal nuance is for each one. Then I am going to take you through the nonviolent felon fight in detail, because that is the most active litigation in this space. And I am going to close with the one legitimate path to restoring federal firearms rights that most gun owners do not know exists. Let me start with the foundation, because understanding the statute's structure explains both how it works and why it is now being challenged from a direction nobody anticipated. Section 922G is part of the Gun Control Act of 1968, enacted in the aftermath of the assassinations of Dr. Martin Luther King Jr. and Senator Robert F. Kennedy. Congress's stated purpose was to keep firearms out of the hands of persons it considered unfit to be trusted with the responsibility of ownership. The statute does not simply say these persons cannot possess firearms. It says it is unlawful for them to ship, transport, receive, or possess any firearm or ammunition that has been shipped or transported in interstate or foreign commerce. That Commerce Clause hook, the interstate commerce requirement, is the constitutional foundation the entire statute rests on, and in practice it covers virtually every modern firearm in the country, because virtually every firearm manufactured in the United States has crossed state lines at some point in its manufacturing, distribution, or retail chain. Courts have held for decades that even a firearm manufactured and remaining entirely within one state sufficiently affects interstate commerce to trigger federal jurisdiction. That is the doctrine Thomas is now questioning. He argued in his Hemani concurrence that Congress's commerce power cannot reach the simple possession of a firearm merely because that firearm once traveled across a state line, potentially decades before the defendant ever touched it. If a future case arrives at the Supreme Court with that Commerce Clause question fully briefed and argued on the merits, Thomas already has his analysis ready. Whether he can get 4 more votes is the open question. Now let me walk you through all 9 categories. The first category is Section 922G(1), the felon-in-possession ban. This covers any person convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year, Three words in that definition carry enormous legal weight. Any court, punishable by, and exceeding 1 year. Any court means state courts, federal courts, and foreign courts, not just federal felony convictions. A state court conviction for a crime carrying more than 1 year of potential imprisonment, even if the defendant served no time whatsoever, qualifies. Punishable by means the maximum possible sentence authorized by law, not what the defendant actually received. A person convicted of a felony who was sentenced to probation and never spent a day in jail is still permanently prohibited, and exceeding 1 year means the maximum authorized sentence must be more than 12 months. A crime with a maximum sentence of exactly 1 year does not qualify. The statute requires the threshold to be exceeded, not merely reached. The federal exception: the statute explicitly excludes offenses classified as misdemeanors under state law where the maximum sentence is 2 years or less. This is the most contested category in all of Second Amendment law today, and I want to spend time on it later in this video because the circuit split and pending SCOTUS petitions require a dedicated treatment. Hold that. The second category is Section 922(g)(2), fugitives from justice. This covers any person who is a fugitive from justice, meaning there is an outstanding warrant for their arrest in any jurisdiction. The warrant must be for a felony. An outstanding misdemeanor warrant does not qualify under this category. Critically, the prohibition applies regardless of whether the person knows the warrant exists. The third category is Section 922(g)(3), unlawful users of controlled substances and addicts. This covers any person who is an unlawful user of or addicted to any controlled substance as defined under the Controlled Substances Act. This is the category at the center of the Hemani ruling, which this channel has covered in full in a dedicated video. But there is a critical update to this category that your compliance picture depends on. On January 22, 2026, the ATF published an interim final rule revising the regulatory definition of unlawful user under 27 CFR Section 478.11, effective immediately. The new definition: an unlawful user is someone who regularly uses a controlled substance over an extended period of time, continuing into the present, without a lawful prescription or in a manner substantially different than prescribed. Isolated or sporadic use no longer meets the threshold. The ATF moved away from the older approach that inferred prohibited status from a single positive drug test or a possession conviction within the past year. What that definitional change does not do, it does not amend the statute itself. 18 U.S.C. Section 922(g)(3) is unchanged, and ATF Form 4473, Question 21(g), the question on every federal firearms purchase form asking whether you are an unlawful user of a controlled substance, remains in force. Answering that question falsely is a federal felony under 18 U.S.C. Section 1001, carrying up to 10 years in prison. The ATF's definitional revision narrowed the pool of persons who qualify as unlawful users under the regulation. It did not change your obligation to answer the purchase form honestly. The fourth category is Section 922(g)(4), mental health adjudications. This covers any person who has been adjudicated as a mental defective or has been committed to a mental institution. Both terms carry specific legal meanings that most gun owners get wrong. Adjudicated as a mental defective requires a formal legal determination by a court, board, commission, or other lawful authority. A finding that the person is a danger to themselves or others, or that they lack the mental capacity to manage their own affairs or to understand the nature of proceedings against them. A voluntary psychiatric hospitalization does not qualify. A doctor's clinical diagnosis does not qualify. A therapist's recommendation does not qualify. A formal legal adjudication or an involuntary commitment by a government authority is required. The fifth category is Section 922(g)(5), illegal aliens and non-immigrant visa holders. This covers any person who is illegally or unlawfully in the United States, and separately covers any person who is admitted under a non-immigrant visa. Non-immigrant visa holders, tourists, students on F1 visas, temporary workers on H-1B and similar visas, are prohibited from purchasing or possessing firearms. The statute contains a narrow exception. A non-immigrant who is in the country for lawful hunting or sporting purposes, or who holds a valid hunting license or permit from any state, may purchase a firearm for those purposes. The sixth category is Section 922(g)(6), dishonorable discharge. This covers any person discharged from the armed forces under dishonorable conditions. Dishonorable discharge is the most severe form of military separation. It is issued only by a general court-martial following conviction of a serious military offense. Bad conduct discharge does not qualify. Other than honorable discharge does not qualify. Only a dishonorable discharge, as formally defined under the Uniform Code of Military Justice, triggers Section 922 G(6). The seventh category is Section 922 G(7), renounced citizenship. This covers any person who has formally and voluntarily renounced United States citizenship before a U.S. consular or diplomatic officer in a foreign country. This is among the least commonly triggered categories. Formal renunciation before a consular officer is a rare and deliberate legal act. The eighth category is Section 922 G(8), domestic violence restraining orders. This covers any person subject to a court order that restrains them from harassing, stalking, or threatening an intimate partner or child. But the statute requires three specific elements before the restraining order triggers the prohibition. First, the order must have been issued after a hearing of which the person received actual notice and at which the person had an opportunity to participate. Second, the order must restrain the person from harassing, stalking, or threatening an intimate partner or child of an intimate partner. Third, the order must include a finding that the person represents a credible threat to the physical safety of that person, or explicitly prohibit the use, attempted use, or threatened use of physical force. This is the category upheld by the Supreme Court 8-1 in United States versus Rahimi in 2024. Chief Justice Roberts, writing for the majority, held that the historical tradition of disarming individuals found by a court to pose a credible threat to the physical safety of others is sufficient to sustain Section 922 G(8). The three-part statutory requirement matters in practice. A mutual restraining order entered without a hearing or without an explicit threat of force finding does not automatically qualify. The elements must all be present. The ninth category is Section 922 G(9), domestic violence misdemeanor convictions. This is the category that surprises gun owners the most, and the one with the most counterintuitive consequences. It covers any person convicted of a misdemeanor crime of domestic violence, a misdemeanor, not a felony. And the definition of misdemeanor crime of domestic violence under federal law covers any misdemeanor offense involving the use or attempted use of physical force or the threatened use of a deadly weapon committed by a person against a current or former spouse, parent, guardian, or other domestic partner. The consequence, a misdemeanor domestic violence conviction triggers a lifetime federal firearms ban under Section 922 G(9), even though the crime was a misdemeanor, even though it would not otherwise qualify under Section 922 G(1) is 1-year threshold, and even though the person may have served no jail time at all. This category was added in 1996 by what is known as the Lautenberg Amendment, over significant opposition from law enforcement organizations, because many police officers had prior domestic violence misdemeanor convictions and were now subject to federal prohibition while on the job. Those are the 9 categories. And now let me go back to Section 922 G(1), the felon-in-possession ban, because what is happening to that category in the courts right now is the most significant active litigation in the entire statute. The Fifth Circuit has struck down Section 922 G(1) as applied to nonviolent felons in 3 separate published opinions: United States versus Mitchell, United States versus Doucet, and United States versus Cockerham, decided in early 2026. All 3 cases applied the Bruen test directly to the felon-in-possession ban, and all 3 reached the same conclusion. The historical tradition does not support permanently disarming a person whose sole conviction was a non-violent offense that posed no danger to others. The Cockerham facts make the constitutional argument concrete. Edward Cockerham was convicted of a single felony, failure to pay child support. He never served a single day in prison. He received a non-custodial sentence. He had fully paid his child support debt by the time he was found in possession of a firearm. The Fifth Circuit held that no historical tradition supports the permanent lifetime disarmament of a person on those facts. The government analogized Cockerham's offense to theft, arguing that founding-era severe punishments for theft, including capital punishment and estate forfeiture, showed that the founders were willing to permanently disable the rights of property offenders. The Fifth Circuit rejected that analogy. Debtors' prisons existed at the founding, but debtors were released upon repayment. Theft was different because the stolen property could not simply be returned. Since Cockerham had fully paid his debt before possessing the firearm, the analogy collapsed under its own weight. The government conceded that distinction during oral arguments. The Fifth Circuit's panel found it dispositive. Now here is the circuit split that makes this legally unstable, and that the Fifth Circuit itself acknowledged is intolerable. The 2nd, 4th, 8th, 9th, 10th, and 11th Circuits have upheld Section 922(g)(1) categorically, rejecting arguments that individual felons with nonviolent histories can challenge it as applied to them. The 3rd, 5th, and 6th Circuits allow those individualized as-applied challenges, meaning the exact same Bruen argument can succeed in Texas and fail in Virginia on identical facts. A Fifth Circuit concurring judge stated it plainly. It is intolerable to have Americans incarcerated in different circuits based on where they happen to live. Cockerham would have remained incarcerated had he pled guilty in any other circuit that categorically upholds the felon ban. He was released because he happened to live in Texas. As of early 2026, the Supreme Court denied certiorari in dozens of cases raising constitutional challenges to Section 922(g)(1), but left more than 10 petitions pending for further review. Those pending petitions include United States v. Mitchell at number 25-935, United States v. Doucette at number 25-1001, and United States v. Cockerham at number 25-1029. The court granted certiorari in several related cases in 2024 and then sent them back to the lower courts for reconsideration in light of Rahimi, rather than ruling on the merits. That posture suggests the court is waiting for the right vehicle, a case with clean facts, a fully developed record, and a legal question presented in a way that allows a definitive answer. Those petitions are the candidates. Watch them. Now let me give you the one thing most gun owners in a prohibited category believe does not exist: a legitimate path to restoring federal firearms rights. The federal relief statute is 18 U.S.C. Section 925(c). Congress created this provision specifically to allow federally prohibited persons to apply for relief from the federal firearms disability. The ATF was originally authorized to process these applications. If granted, the prohibition is lifted, fully and permanently. Here is the problem. Since 1992, Congress has attached an annual appropriations rider to every ATF budget prohibiting ATF from using any appropriated funds to process Section 925(c) applications. The pathway has been legally available in the statute and practically inaccessible in reality for over 30 years. Courts have held they cannot compel the ATF to act on applications it is prohibited from funding. In 2025, the DOJ found a workaround. The Attorney General withdrew the delegation of authority from ATF and began processing Section 925(c) applications directly through the Attorney General's office, bypassing the appropriations rider that specifically names ATF as the prohibited spender. Because the rider bars ATF from using funds on these applications, having the Attorney General's office handle them sidesteps the restriction. In March 2025, the Attorney General granted relief from federal firearms disabilities to a group of individuals under this revived process. Whether this pathway remains available depends on future administrations and whether Congress modifies or removes the appropriations rider. It is a DOJ policy decision, not a statutory right, and it can be rescinded. But as of now, it exists. A presidential pardon is the second federal route. A pardon can lift the federal firearms prohibition entirely. Pardons are granted rarely and involve a lengthy petition process through the DOJ's Office of the Pardon Attorney. They are not a realistic near-term option for most people, but they are a legal option. State expungement is the third route and the one with the most dangerous misconception attached to it. A state court expungement of a conviction does not automatically restore federal firearms rights. Federal law has its own definition of when a conviction counts for Section 922(g) purposes. A state expungement restores federal firearms rights only if it restores all civil rights, including the right to possess firearms under state law, and only if federal law recognizes the state's process as doing so. Many state expungements do not explicitly restore the firearms right. Those expungements provide zero protection against a Section 922(g) prosecution. If you have a state expungement and you believe your firearms rights are restored, you need a licensed attorney to verify that conclusion under federal law, not a general assumption. Some states maintain their own relief from disabilities process separate from expungement. A state relief grant restores the federal right only if federal law recognizes the state's process as adequate, which requires that the state's law provides for a genuine hearing with a real opportunity to demonstrate fitness for possession. Not every state process qualifies. Let me close with the compliance picture, stated precisely because this is what this video exists to deliver. Section 922G applies to the act of possessing, receiving, shipping, or transporting a firearm or ammunition. You do not have to purchase a firearm to violate it. You do not have to fire it. You do not have to carry it in public. Being in knowing possession of a prohibited firearm, in your home, in your car, in a storage unit, is the federal offense. The government must prove knowing possession, that the defendant knew he possessed a firearm. It does not have to prove the defendant knew he was a prohibited person. Ignorance of your prohibited status is not a defense to a Section 922G prosecution. The ammunition trap is real and under-discussed. Section 922G applies equally to ammunition. A prohibited person who possesses a single round of .22 LR is violating the statute with the same maximum exposure, 15 years, as a person possessing a loaded rifle. If you are in a prohibited category, the ammunition in your home is not a gray area. It is a federal felony. The litigation landscape is moving. The ATF's January 2026 definitional revision on Section 922, G3, the Hemani ruling, and Thomas's Commerce Clause invitation, the pending nonviolent felon petitions at SCOTUS, the Fifth Circuit's three-case line striking down lifetime disarmament for nonviolent offenders, all of it is moving simultaneously, but no court has struck down Section 922G categorically. No court has declared any category of this statute facially unconstitutional. Until a court with jurisdiction over your state issues a ruling that specifically and directly affects your prohibited category, the statute is fully in force and fully enforceable against you. Justice Thomas wrote that courts should revisit the constitutionality of Section 922G. He was writing for himself, but he was also telling you something. The most enforced federal gun law in America, the statute that has permanently disarmed millions of citizens since 1968, is now under simultaneous constitutional challenge from the Second Amendment, from the Commerce Clause, and from the historical tradition test the Supreme Court established in Bruen. What that statute looks like in 5 years may be very different from what it looks like today. But today, it is the law, and you need to know exactly what it says.